jury trial. Appearance for the record.
Good morning, Your Honor. Lisa Lindsay on behalf of the people of the state of Michigan.
Please court Robert Ryan, Assistant Prosecutor.
Matt Muscat, Assistant Prosecutor.
Mark Henley on behalf of the people.
Lily Riel on behalf of Robert Bashara, who's present to my left.
Michael McCarthy on behalf of Robert Bashara.
Okay, very good. You may be seated. How you feeling today, Mr. Bashir?
I'm okay, thank you. Your
Okay,
Honor.
because some concerns about your health over the weekend.
I'm sorry?
Some concerns about your health over the weekend.
Well, I was in hospital last night, but I'm hanging in there.
Okay.
God willing. Thank
Okay.
you.
All right, thank you. Okay, very good. The court is in receipt of a order from the Supreme Court in which we wish to clarify that it is this court's understanding that at the point of the proceeding, defendant delayed statement concerning insulin have been ruled inadmissible. That is what the court indicated. The court indicated on the previous motion that the court believed that the issue of the statements made by the defendant regarding any insulin and or the use of that evidence, I'm modifying if I didn't say it before and I thought I did, the court believed was not relevant, that it was just too remote based upon the time of the statements that were made. So that's what the court's ruling is.
Judge, can we get we need a written order just so that we can comply with the court's order. In addition to that, since we had our hearing, there's been two additional pieces of information that I was placed on the record. First, Teresa Giffen told us that the defendant was aware that insulin overdose would result in death.
You know, maybe.
Okay. I didn't, here's the situation, right? We had our motion hearing, okay? There was nothing filed supplementally with this court asking to reconsider its decision based upon this new evidence. I'm just hearing it today. So at this point in time, I've ruled. I mean, it's clearly the eve before trial. There was ample opportunity. Madam Clerk, can you assist me when we were here last for the motion hearing?
Judge, this issue.
10:10. I'm sorry, madam. It was the date that the court entered some motions. I don't believe it was 10:10, madam.
September 8th.
September
Yes,
8th.
ma'am.
Thank you so much. So we were here on September 8th in order, and the court argued these motions. And then I'm getting information on the eve of that there's some new information that's forthcoming.
Yes, sir. And I think at the time we indicated to you that we were going to appeal. We did that. We just got this order from the court, from the Michigan Supreme Court, asking for a clarification of the ruling. In the meantime, that evidence has developed. We've shared that with counsel. They've got the statement that we took, I believe it was 2 weeks ago, from Ms. Giffen. And the last witness statement, she indicated that at that time.
Your Honor, we would ask that he not place that on the record simply because we have cameras and all of that going on until we have a ruling. This statement was made October the 4th in preparation, I believe, of trial. It was a Saturday. So all of a sudden we have this evidence conforming. I would ask, Your Honor, hold that in abeyance and that we not place those details on the record until there's an official ruling. Ms. Giffen can certainly get up there and testify, but we haven't even gotten there yet. I would ask that the prosecutor not try to testify ahead of the trial.
Well, I'm not, Judge. I'm simply trying to inform the court of what evidence we have and why, in light of the court's order from the Michigan Supreme Court and the additional evidence, the court may wish to reconsider its prior ruling. That's all I'm attempting to do. We just got this
Okay,
evidence.
first of all, the court has not had an opportunity to consider the evidence in the context in which it was made. There's been no motion before this court. It's just you're saying, well, a witness said this. It's just not properly before the court.
Thank
If
you,
you
Judge.
wish to allow me to reconsider my motion, you have to put that in written form.
Yes, sir.
And the court will deal with that before that witness is presented. And when can you get that to me? Can we?
You have it tomorrow, Judge.
Very good. And we can resolve that matter Friday. Are you available?
Yes, sir.
That's fine.
Yes, sir.
Okay, very good. Just motion it up and we'll deal with that. So the court is gonna indicate for the record that at this point, I am going to rule that, we'll strike that. The court's gonna rule that the defendant's statements are inadmissible. However, as to any other witness being allowed to testify, I'm gonna hold that in advance until that motion's filed and I can properly deal with that at the hearing.
Thank you, Your Honor.
Okay,
Thank
very
you,
good.
Judge.
Okay, anything else?
Not objective.
Why have you done that? You said they're not right? Oh, the ones that you brought up. Okay, here, and take them.
Judge, I'm not certain whether we did this prior, but at this point, we would like to ask for mutual sequestration order.
Oh, clearly. The court is gonna indicate that any and all witnesses in this matter, are to be sequestered. And the court is also going to indicate that, that not be allowed to, discuss the testimony. And if in fact the court does find out that there was a violation of that order, the court will not allow that witnesses to testify or strike their testimony. So make sure that your witnesses don't discuss their testimony with one another.
We just asked the officer in charge to be excluded.
Any objection?
No. We just asked the
There's two
officer.
officers in
No, I'm
charge.
saying any objection. Any
Oh, I have no
objection?
objection to that rule.
Okay. As to the officer in charge.
No objection to that either.
There are two, just for the record. Captain Locke.
Any objection?
No.
Your Honor, Mr. Lillian Diallo read on her witness list that the defense investigators may testify. For that reason, I note there in the courtroom, I ask that they be removed from the courtroom.
Your Honor, if they do testify, it will be after, for rebuttal only. They are not fact witnesses. There's nothing that would prevent them from sitting here and listening to the testimony. We do note that, you know, they have their two investigators in the courtroom. They are actually going to testify. These gentlemen are just going to help assist us in what we need to do to present evidence, the statements and all of that. But no, they would not be called directly on when we do our case. So if there is something that comes up in the prosecutor's case afterwards that we might need them, I will give this court a heads up. But as an officer of this court, Judge, I do not anticipate they will be testifying. As a matter of fact, I can certainly say Mr. Gillespie will not be testifying and Mr. Bruce will not be testifying unless there is an issue that is unanticipated, and we would hope there would be no more
I'll allow
unanticipated issues. Thank you, Judge.
Yes.
All I was saying is we asked to exclude that. Since they didn't ask to exclude it, I did not know anything. So that I was just clarifying, just like we asked to exclude ours, if they wanted theirs to be in the courtroom, they could have asked to exclude theirs, and none of this conversation would have had to take place.
Very good. Thank you so much.